It's great to be here. I'm sorry I can't be there in person. I was last in Israel in November. I plan to be back a little bit later this year, but I'm currently in Atlanta, Georgia, USA, and it's great to participate and to be involved in this. As Adriana mentioned, I'm Greg Kirsch, and I head up the IP department at Smith, Gambrell and Russell, an American law firm with offices around the United States and also in Europe as well. And we've got about 30 IP attorneys, about 18 patent attorneys and patent agents. And I've been working in this field for about 32 years now and focused very heavily on software type inventions. I'm a patent attorney by training with computer engineering background. And so let me share my screen here. I've got a presentation that hopefully I can pull up here. And can everybody can see my screen? Hope the answer is yes. If not, let me know. So we're going to talk about strategies for patent protection for computer software in general and AI, artificial intelligence in particular, in the biomedical sciences. And I'm also going to talk. You'll see that the subnote here is separating myth from reality, because there's a lot of misunderstanding, as you probably know, with patents for computer technology in general and software and AI in particular, in general, and also as applied to biomedical inventions. So I'm going to talk about that. I'm going to try to clarify a few things and present some case studies as well. So hopefully you can see that I move to the next slide. If not, let me know. And I know sometimes Zoom can be a little bit finicky in how it operates. But I'm going to just spend a few minutes on some slides, just some introductory slides here. As you all probably know, since you're operating in this field, software and artificial intelligence can take many forms when it comes to biomedical inventions. It can be standalone software, what we oftentimes refer to as software as a medical device. This is software that's used for medical purposes, but not part of a medical device per se. It could even be software used in collaboration with drugs, with pharmaceuticals. It could be bioinformatics or medical informatics, the study of biological data or patient data. It could be medical care management software. This is all standalone software as opposed to software that might be embedded in a medical device, what we oftentimes call software in a medical device. These are two terms of art that you're probably familiar with, SAMD and SIMD, software as a medical device, where the software itself is basically the medical device for purposes of the FDA, et cetera, or software that actually controls or allows you to use or calibrate a medical device, what we call software in a medical device. And software, as we also know, can be used to design biomedical inventions, medical devices, and other types of devices and hardware. It can be used in the production, testing, quality control, et cetera. And then, of course, lastly, this is oftentimes forgotten, but software can be used in communication technology to control the communications that go back and forth between different medical devices and biomedical technology in general. So not necessarily the biomedical device itself, but rather how it communicates with the outside world. So there's all types of ways that software can be used, both internally and externally. And so I just wanted to kind of set the stage for the rest of my presentation. With respect to software, I'm not going to get into a lot of detail here, but as you probably know, since you're in this field, there's different types of software. There's conventional software, which kind of takes a top-down approach. It performs computers can be programmed to perform specific tasks. And then there's artificial intelligence, which is a type of software. And again, I've grossly oversimplified here, AI, but typically the way I like to explain it is, artificial intelligence is not programmed to perform a particular task, but rather to learn to perform tasks, with data labeling, to kind of put context to data, machine learning, finding patterns, feedback loops, et cetera. Again, I'm oversimplifying this, and some of you may be artificial intelligence experts, which you might be looking at this and saying this is a gross oversimplification. But given time constraints, I just wanted to kind of explain that that artificial intelligence is a subset of sorts of software in general. And for purposes of patentability, which we'll talk about in a moment, the different types of software, whether it's just conventional software or AI, are sometimes treated a little differently in how the patent office and even the courts will look at patentability of these kinds of inventions. I think the audience here is, there's a spectrum of you. Some of you may be quite familiar with patents in general and the U.S. in particular. Some of you may not. So I'm just going to kind of give a brief overview, very high level, but it's important to understand, how patentability works in the United States. There's three main tests for patentability. The invention has to be useful and it has to be of the proper subject matter. That's what we oftentimes call 101, the 101 test. By the way, are you seeing the, I just realized that I have a disconnect on this end. Are you seeing the slide that says patentability at the top right now?
We're not.
Okay, so have you not seen it advancing?
Yeah, it's not advancing.
Okay, thanks for, I just realized that I'm moving it forward, but it's not advancing. Let me do one other thing. I think I can fix this real quick. Just a moment. I'm just gonna pull up the non, okay, here we go. Do you see where it says patentability now? At the top?
We do.
Okay. All right, good. Yeah, sorry about that.
They said here to make this into presentation mode.
Yeah, I did make it into presentation mode, but sometimes when you put it in presentation mode, it does not allow you to advance the slides when it's being projected. So okay. If it's okay, I'm gonna keep it not in presentation mode just so we can see the slides from slide to slide.
Okay.
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 So everybody sees. So I'll just kind of go back real quick. This was the first slide that I think you did see, but then I talked about software versus AI in general, and then the requirements for patentability is what I'm on now. But you see the slides moving now, right?
Right.
Okay, great. Okay, so for patentability in the United States, we have utility and subject matter. What we call 101. This is the statute, the law, the particular law in the United States. And then we also have novelty and non-obviousness. These are the three tests for patentability. The invention has to be useful and it has to be of a certain subject matter, but it also has to be new, novel, and also non-obvious. And so there are particular challenges that we face when we're dealing with software and artificial intelligence, not just for biomedical inventions, but for any kind of technology that uses software and AI. But there are some particular challenges for biomedical inventions. And the nature of software itself kind of implicates all three of these tests: utility, subject matter, novelty, and non-obviousness. We'll talk about that in a moment here. So let's take the first one, utility and subject matter. So to be patent eligible, so before you even get into whether invention is new and non-obvious, to be patent eligible, the invention has to be useful. It has to have utility, which has to be a credible utility. And usually in the biomedical space, software, whether it's internal to a medical device, for example, or whether it's a software as a medical device or some other type of auxiliary type function, usually that aspect is fairly easy to show. Since we're dealing with biomedical inventions, there's usually a use that can be fairly readily shown. The difficult part gets into the subject matter, where we're under 35 USC 101, which is the statute, the law that indicates what type of inventions are patentable. To be patentable, the invention needs to be a process, machine, manufacture, or composition of matter. Not surprisingly, software and artificial intelligence typically fall under the process or machine category. So that's fairly straightforward. However, over the years in the United States, the courts have interpreted subject matter eligibility to exclude certain types of inventions or discoveries. For example, laws of nature, which things like gravity, for example, or that would also fall under natural phenomenon. So laws of nature, natural phenomenon, abstract ideas. So, for example, gravity or a mathematical formula equals mc squared, or the relationship between one thing in nature and another thing in nature, or just simple concepts like business methodologies. Taken by themselves, those are typically excluded from patent eligibility. Those are not tangible enough, those are not technical enough to be patent eligible under this requirement. And I'll talk a little bit more about how that's actually applied in fact with software and AI. One myth that I hear a lot, and I work with a lot of software companies, small startups to very large multinational companies, and a lot of universities. I do a lot of work with these kinds of entities, and I constantly hear the myth of software is not patentable. I'm not interested in pursuing it. And that really is not true. And I'll explain what I mean in a second. And Adriana mentioned earlier that nobody's trying to convince anybody that you should get a patent on software. But before that decision's made, you have to understand how the rules work, because in some cases, software is, or at least aspects of software is readily patentable. In other cases, it's not. And it all depends on how you actually define the invention. So you may have all heard of a case from about 8 years ago, the Alice Corp case. It's a U.S. Supreme Court decision from 2014 that basically tried to quantify and tried to create additional rules as to what is patentable and what is not, especially with respect to software. And if as long as the invention is claimed as a process or machine, which it typically would be with software or computer technology, and as long as it does not fall into one of these judicial exceptions per se, laws of nature, natural phenomena, abstract ideas, then software can be patentable. And even if it does fall, even if aspects of the claim fall into a judicial exception. So for example, let me back up a slide. Let's say you have a mathematical formula that is used in the invention. Let's say to control a medical device. Let's say it's some kind of medical device. It's controlled with a computer processor and software. There might be artificial intelligence built into it, maybe not, it doesn't matter. But the fact that there is a mathematical formula at play, if that mathematical formula, for example, is used for a practical application, for example, to regulate the flow of blood, or to apply electrical impulses to control your heartbeat or something like that, and the fact that it's using a mathematical formula to do that, but the end result is some practical application of it, then that would basically take something which would otherwise fall under one of these exceptions, law of nature, natural phenomena, abstract ideas, and make it so it doesn't, because you have a practical application of that, let's say, law of nature, or that natural phenomena. So in addition, let's say you have some kind of judicial exception here where otherwise the invention would not be patent eligible. But if you have additional steps, let's say the result of that is to feed into, one device feeds the output that's created with mathematics, for example, into another device, and then that other device then performs different functions to operate a medical device of some sort. That would be another way that something which might otherwise be a judicial exception, where patent eligibility would not occur, would suddenly become patent eligible if that were to occur. So as you can see, it's all how it's claimed. You may be familiar with, claiming in patent applications and patents. It's in addition to describing the details of how to actually make and use the invention, we actually define the scope of what it is you think you invented. And if you define the scope purely in mathematical terms, for example, you're probably going to get rejected at the patent office. Or if the patent finds, sees its way through and is granted, it'll probably be held invalid as a judicial exception by the courts or by the patent office. But if you claim it with these practical applications or these extra elements that make it, to pull it out of the judicial exception, then it can be patentable. So to say, just to say software is patentable or is not patentable is almost a meaningless thing to say, because it all depends on how exactly you are defining your invention. Are you incorporating patent eligible aspects? If you are, then it likely is patent eligible. So let me give you a little stat here, a little statistic. This is something that I looked up on the U.S. Patent Office website, and I found it very interesting. I'm going to show you two slides here. The first one is the percentage share of U.S. issued patents that claim software-related inventions. So, the software may not be the heart of the invention overall, but the invention has some aspect to it that is software-driven, computer-driven. And this is not just for biomedical inventions. This is for all patents filed in the United States and all issued patents in particular. So, we start off in 2002 and end in 2020. And as you can see, the percentage share of U.S. patents that include software-related inventions has steadily increased. And this is even after 2014. This is the Alice Corp decision, which actually kind of made it harder to get patents on software-related inventions. But even so, there was a small dip right here. But since then, it's gone up, up, up. It's now in almost 65% of all issued patents have some software aspect to it. And this goes across the board with all types of inventions. This is a fairly high percentage if you think about every single invention, biotech, chemistry, mechanical, electronics, whatever it might be. It's a fairly high percentage. I was actually quite surprised to see this percentage. And the next slide here shows not the percentages, but the total number of U.S. issued patents that claim software-related inventions. And as you can see, it has risen from about 75,000 per year in 2002 to now about 225,000. So quite an increase over just a period of 20 or so years, not even 20 years. Small dip between 2019 and 2020, but I believe that the numbers for 2021, which I've not yet seen, have it going up even higher. So, patents for software-related inventions continue to increase, and that also includes biomedical inventions. So another myth that I hear quite a bit is in the biomedical space. I hear that people say, well, when pursuing patents, it's oftentimes more important. It's usually more important to pursue patent protection on the biomedical technology hardware as opposed to the software itself. Let's protect the hardware itself, and the software itself may not be as important to protect. This depends. It sometimes is true, it's sometimes not true, this myth. But more often than not, the more we see software kind of embedded into all types of biomedical applications, we're seeing it more often than not true. Because in some cases, the hardware itself might be improved, but in some cases, you have existing hardware, existing biomedical technology that has been improved purely by creating additional software. And oftentimes these days, that includes artificial intelligence built in. And oftentimes the new and non-obvious aspects are the software AI itself. Sometimes it's a combination of the two. But again, this myth, which I hear quite a bit, I hear this from university clients. I also hear this from companies of all sizes, very sophisticated, larger companies and startups as well. Simply not true. Let me give you a little case study. This might explain it further. I do a lot of work with universities in Israel and all over the United States. I think my firm represents about 20 different universities where we help them get patents and help them license patents. And just in the last few years, I was working with a major U.S. university. I won't name the name, but we were working on some computed tomography imaging inventions. This is basically, as you probably know, computed tomography is a medical imaging technique where you can get detailed internal images of the body for diagnostic purposes, et cetera. And the inventor at this university developed this very interesting artificial intelligence technique to reconstruct images and to highlight and augment the images in new ways. They were using it for diagnostic purposes to identify different, I think in this case, it was different cancers and other types of diseases. But the images themselves, as created by the X-ray device, were not sufficient. So they had to augment them. And this inventor, this professor at this university, created this artificial intelligence technique using deep learning, which is a type of machine learning, to create better image reconstruction. And the patent claims, when we filed the patent application, the claims were directed solely to the software because the X-ray machine itself, the X-ray system, was old. It was an existing, state of the art, but it was an older system, nothing new there. But the imaging techniques were what was new, completely driven by software and artificial intelligence. And we ended up licensing, the university ended up licensing this patent family. We ended up, I think, with 3 or 4 patents and a couple more that were pending. We licensed it to a major X-ray device manufacturer to use on their existing systems. So that, again, they were not interested in any hardware changes. They were purely interested in the imaging techniques that this inventor had created. So very, very good stuff, very lucrative for the university, a lot of royalty revenue coming in from that. Another example, it was a different university client. They had developed an invention to automate the detection of different eye conditions by looking at somebody's eye using imaging techniques. Using artificial intelligence, they were able to detect different anomalies, and we filed a series of patent applications for them. The patents were granted. We ended up licensing them to a company that is, in this case, it was kind of a mid-sized company that is further commercializing them, and the patents ended up being a major value point for negotiating with this company, and so far the company is doing very well with this technology. So, again, without the patents that were purely software driven, in this case AI driven, the deal would have never happened. This company would have never been interested in the technology. Again, separating myth from reality. So the biggest challenges, and I know I'm coming up here on 5-10 minutes left. The biggest challenge, just to kind of wrap things up here, is delineating between the abstract ideas and the practical applications. I mentioned that this is the test for 101, the patent eligibility, and that dividing line is not always clear. And so, we used to see a lot of these rejections. We're not seeing as many now, but we did see a lot of, abstract idea type rejections. And but what we have found is that with careful claim drafting, where we are focusing not just on the abstract ideas, but on the practical applications, we can oftentimes make this a non-issue, that these patent eligibility requirements do not apply, that this is clearly technical enough and practical enough to be patent eligible under 101. And again, as I said, especially with biomedical inventions, we are seeing much fewer rejections at the patent office for these types of inventions, whereas maybe even 4 or 5 years ago we would see quite a bit of them. The case law has developed. The U.S. Patent Office has developed some guidelines that allow us to draft the claims in a way that maximizes the chance that this will not be an issue. The bigger issue, and this is actually not talked about nearly enough, but the biggest issue here is not patent eligibility issues, but really it's novelty and non-obviousness. It's basically comparing the claimed invention to the prior art, because as you probably know, if you're in this space, the most software publishers or most companies, including the biomedical field, that use software either embedded into their medical devices or as standalone software, they oftentimes will only distribute the software in executable form. They will not make the software open source, and available for everybody to see. That there's some exceptions to that, and you'll see some open source type situations. But for the most part, it's closed code. It's code that is written, distributed, embedded in devices, but the source code is not released. That's kind of the crown jewels. And there's no need, if you're selling some medical device that has embedded software, there's no need really to distribute the source code. The device just has to work as it's intended to work. So the biggest issue that we see with software in any field, including biomedical devices or biomedical technology, is the fact that when you file a patent, it may be difficult or impossible to find the best prior art, because the patent office has to review your patent application and claimed invention in light of the prior art, prior publications, prior patents, etc. But if they don't have access to that, because nobody is freely distributing, for the most part, source code, it's hard to know what that state of the art truly is. So what I always recommend to my clients is, let's not rely just on the US Patent Office, the examiner at the patent office, to do prior art searching. Let's do our own searching. And again, it may be hard for us as well to do the searching, because again, other parties are not publishing the details of their code. So let's use competitive intelligence. Let's find maybe inferential ways to figure out what others are doing. And let's also try to predict the scope of the prior art. Even if we don't know for sure what the prior art is, let's at least include some maybe narrower claims that we think will distinguish over what we think that prior art looks like, even if we can't prove it, because that will only serve to increase the quality of the patent. Otherwise, if you're completely relying upon the patent office to do the search for you, you may end up with a patent, but that patent will be so broad, it will be easily attacked later on if you ever assert it. So that's one issue that I think is oftentimes overlooked by many people. Another similar issue, is infringement detection. And this really gets into what type of inventions make for good patents. Sometimes you have an incredibly clever invention, which might be very valuable, but if you're not able to detect infringement in a competitor, that patent may have less value. Because if you don't know if it's going to be very difficult to determine whether your competitor or a competitor of your licensee is infringing, then sure, you might have a patent, but what are you going to do with it? How are you going to assert it if you need to assert it down the road? So sometimes just observing the operation of an accused system, a competitor's device or process, may not be enough. You may not be able to figure out what's actually happening, especially if it's software related, kind of in the bowels of the device itself, because this is embedded software. The source code is not published, so you have to maybe guess as to how it's actually operating. Now, you can sometimes reverse engineer. We've actually done this for some of our university clients, where we thought that there might be infringement. We've done some reverse engineering, which is allowed, to determine how that accused device might be operating. You can even do that to a degree with software. It's a little harder because you have to do a lot of decompilation and whatnot, but there are ways to do that in some cases. There's also inferential analysis. You can look at what the device is doing and infer, in some cases, not always, but infer how it's operating. Sometimes you might be wrong about that, but you can do that. I'm sorry?
Greg, we have to wrap up.
Okay.
Some people have some questions, so.
Perfect. Okay. Well, I'm at the end here. This is some takeaway slides. This is just a repeat of what's been said before, so I can conclude right there.
Masha's telling me that you can go over your key takeaway points quickly.
I can?
That's what Masha said.
Okay. I'll be very quick then. This is just kind of a wrap up of what I've talked about before. Again, software and artificial intelligence can be patentable. There's a lot of patents filed in these areas, including in the biomedical fields. lots of successful outcomes. We've seen a lot of these with our clients. It's not for everybody, and you have to understand and look at whether it makes sense for your technology, but don't just assume that it does not make sense because software or AI is involved. One thing I'll say, and I didn't really mention this before, but one very common and very effective, it can be very effective approach is to not just patent what you are doing, what your university or your company is doing, but to look at your competition and see what areas that they are going into that you may be able to get some meaningful patent protection, even if it's not core to what you do as a company or university. And this is often overlooked, but I've seen it play out very, very effectively, where you can basically block your competition, which might, discourage them from coming after you with any patents that they might own. And the last takeaway slide, again, this is just a summary of what we talked about, is with biomedical inventions, software and AI inventions in particular, with the right claim drafting, that's what it's always all about. An invention can have claims drafted correctly or incorrectly. In one case, the claims may be rejected repeatedly as being non-patent eligible. In the other case, they may sail right through. So it's all about claim drafting. And the prior art is a focus that we all need to put into it. Sometimes this is overlooked, but using competitive intelligence and prediction of what prior art might look like, you can create some meaningful patent protection. And finally, the revealing aspect or non-revealing aspect of inventions. Always important to take that into account. You don't want to end up with a patent at the end that you realize is going to be very, very difficult to even detect infringement of, in which case the value of it goes way down. So that is my key takeaways, and I am open to questions.
Anyone? Masha, anyone from the chat?
Hi, Greg. How are you?
Hi, good.
So one question regarding the slides you showed about the numbers of patents that are related to software and AI. It seems to me that it's very surprising that in our world in the last 5-6 years, where everything is about software and engineering, the rise is not much higher. It seems to me that it shows that the many technologies in these areas are not patentable at all.
Interesting point. Well, let me go back. This is the total number of patents. Let me go back one slide to the percentage share, and you'll see it's almost 65. It's like 64% as of 2020, and that's a fairly, in my mind, that's a fairly high percentage overall. If you think about all the different types of inventions that people pursue patents on, it's not just devices or computer-related inventions. It's biotechnology, it's pure mechanical inventions, it's chemical inventions. So I think it's if you look just at those types of inventions where software could play an important part, I think I agree with you. I think I'm surprised it may not be even higher than this, and it probably is. But this includes every type of inventions, from biotechnology to chemistry to mechanics, et cetera. And so if you look at every type of invention, whereas I think it makes more sense that this is probably an appropriate number.